I am Hannah Woolaver from the University of Cape Town, and I wanted to add my welcome and thanks to IAMO for organizing such a fantastic event. It's been a real honor for UCT to play host, and thank you for including me in today's program. For this last panel of the day, we'll be looking at the role of non-governmental organizations in the investigation of international crimes. Now, civil society has played an increasingly important part in the fight against impunity for international crimes, both domestically and at the international level. A key and well-known example of this is the significant role played by civil society actors in the drafting of the Rome Statute of the International Criminal Court. However, as we know, once the court was established, the opportunities for intervention by civil society have proven more limited than might have been desired. Civil society only has two options for formal interventions in ICC proceedings, either through written representations to the Office of the Prosecutor to press for investigation and prosecution in a particular situation using the Article 15 mechanism of the Rome Statute, or through submission of amicus curiae briefs once proceedings have begun. However, these limited opportunities for formal intervention at the ICC do not fully reflect the important functions undertaken by civil society domestically, regionally, and internationally. So, for example, civil society has taken it upon themselves to collect evidence of international crimes, represent victims, they've run campaigns to overcome political opposition to accountability, provided legal expertise, to name just a few of the crucial functions played by civil society. Now, these crucial activities are often undertaken in the face of strong political opposition from state governments, and at times with personal risk to the members of the civil society groups. A good example is, for instance, in Kenya, where civil society is widely referred to as evil society in the media. In South Africa, we've seen the impact that non-governmental organizations can have on international criminal justice issues, with landmark domestic litigation being driven by civil society groups, as we shall hear more about during the course of the panel. And at the same time, experience shows that there are some risks to the legitimacy of international crimes investigations and proceedings when civil society participation is not adequately regulated. So it's therefore an opportune moment this afternoon to reflect on the appropriate role of civil society, and NGOs in particular, in contributing to the ending of impunity for atrocity crimes. And this afternoon we'll hear from two fantastic experts on this central topic. First, we will hear from Ambassador Stephen Rapp, Ambassador at Large for War Crimes Issues, Office of Global Criminal Justice at the U.S. Department of State. And I must say, Ambassador Rapp, there's a general consensus that that is the best ambassadorial title that one can be given. Ambassador Rapp was also previously prosecutor at the Special Court for Sierra Leone and at the ICTR. We will then hear from Angela Mudukuti, who's the legal officer at the Southern Africa Litigation Center in Johannesburg, and SALC has played a crucial function here in South Africa in terms of the implementation of international criminal law obligations in the domestic law of South Africa. I will give each panelist 15 minutes to deliver his or her remarks, and then we will open up for general discussion. And I know that there are representatives of several very prominent civil society groups here focused on these issues, so I look forward to all of your participation in the debate afterwards. We will end promptly at 4:30 to allow our panelists to catch her flight back to Johannesburg. Okay, thank you, Ambassador Rapp.
Okay, well, thank you very much, Hannah. And just a slight correction, in August, I finished 6 years as Ambassador at Large, which was a great position, and during which I was, I think, to South Africa about 5 times, the DRC 14 times, and very proud of flying about 1.6 million miles to 87 countries, and always on every stop, the first stop was civil society and victims groups, without whom this project can't succeed. I'm continuing that work now since October, jointly for the U.S. Holocaust Museum's Center for the Prevention of Genocide and the Hague Institute for Global Justice in The Hague, where I'm now resident. But you're right that I came to that diplomatic experience from a career as a prosecutor, as a United States attorney, a federal prosecutor in the United States, and then for 9 years at the international level, about 6 at the Rwanda Tribunal, first as a senior trial attorney leading the media trial, and then as chief of prosecutions under Hassan Jallow, and then went over to West Africa to be chief prosecutor, the head prosecutor, in charge of completing the work of that court, including the trial of Charles Taylor that we moved at the request of the neighboring countries to The Hague while we tried our other cases in Freetown. This experience taught me that nothing is as important as having strong evidence, good witnesses, good documentation if you're going to court. I was familiar with organized crime cases in the United States, in which there's profound pressure on witnesses not to testify. There's some kind of a code of silence that you have to get around, tremendous threats to every aspect of prosecutions. These international criminal cases, particularly when you're dealing with active armed groups or with government authorities that are still in power, are even more difficult. And of course, the legal basis upon which we hold those leaders responsible require, sometimes you can have a command responsibility case, but most often you can't do that. There's not a direct line of responsibility between a government minister and the Interahamwe, just as there wouldn't be between Bashar Assad and the Shabiya militia. You have to have evidence to prove those cases. And in the course of my work as ambassador at large, I engaged actively with the ICC as we became a very active non-party partner of the court under President Obama, where we could help the court in kind with bringing in fugitives like we successfully did with Ndaganda and Ongwen, but also ways we could help with investigations. And I always ask the former prosecutor, do you need some help with investigations? And he'd say, oh, we've got plenty of evidence. And I was frankly skeptical because it seemed to me that the investigative unit of the ICC started much too small. Even today, and it's certainly Patu and James Stewart are trying their best to get it increased. I think they're up to 79 professional investigators, perhaps a third to a quarter the size of either the ICTY or the ICTR's investigative force that were dealing with one situation. That permitted those courts, in fact, as they closed, to share evidence with national systems, a very active effort of the ICTY with 11 BIS transfers, but also with transfers of non-indicted cases, liaison prosecutors, scores of requests coming in from the region and from other places about the investigations. ICC doesn't have that capacity at all, and it's just amazing to me. But unfortunately, given the budgetary issues and the difficulty once you start small, because you'd have to take the budget away from somebody else, it's almost impossible to correct. So the question is, where can you find the investigative capacity to put together some strong cases? And as we care about victims, I mean, I can imagine nothing worse than a victim that's been horribly violated, who's lost their family, who's bearing permanent injuries psychologically and physically, to watch a proceeding fail in front of them. Because the prosecutor came in with too weak a case. I mean, this is what costs us all sleepless nights. And we have to bring this thing forth, and it takes an immense amount of information. I used to say in national prosecutions, you shouldn't go in until you have twice the evidence you think you need. The international level, I'd say maybe 3 times, given the vulnerability of witnesses to pressures. So how are you going to fill that? There's an interesting experiment now. We'll see how this works, and I'm glad that Simo's here. One of my passions has been the Central African Republic, and I'm so pleased that President Samba Panza is joining this expert group. But that court, that president has referred a new case to the ICC. We're hoping the ICC will soon indict 2 to 4 warlords. But there's a recognition that that's not enough, that the national system has been totally and completely broken. And that led to the establishment, with human rights groups and victims leading the charge, of a special penal court that will have 14 national judges and 13 international judges, a mix with a national majority, we'll see, whether the resources come to do this. But one of the interesting things in the statute is that court will share evidence with the ICC and move back and forth, a kind of complementarity that's kind of a two-way street. Now, maybe that can work, but of course to rely on what's going to happen there to build cases in a place where building that court at all will be challenging, I think is perhaps the triumph of hope over experience. Now, the question is, where do we get the evidence? And Navi this morning was talking about commissions of inquiry, and it's a subject that's actually what I'm working on at the Hague Institute. And these have been extremely important and write fantastic narrative reports and keep the issues to the fore. But they're dealing with human rights law. They're not collecting, to a large extent, documents, videos, forensic evidence. They take witness statements, and because of confidentiality, those are unlikely to be available. So the examples where these commissions of inquiry have been able to share anything with international justice is very limited. We hope to be able to expand that space. So what do we try to rely on? And of course, as we note, there are human rights groups that are active in this field that have a great deal of credibility: Human Rights Watch, Amnesty International. I'm just naming two. There are others that do great reports and keep these issues in the front and center. Their focus is largely advocacy. They also, and I know indicate there's a human rights investigators privilege. I mean, they're not in a position to really share their evidence, though they can be enormously valuable. The late Alison DeForge, the greatest people I've ever known in the field of dealing with what happened to the Rwanda genocide, testified in 11 of our trials in Arusha as an expert witness. But also an accumulating witness who could bring in other documents and put the picture together for the judges. Without her testimony, Arusha would have been a failure. I can just say that, full stop. The rest of what we had would not have been sufficient to carry our cases. So it was her putting her heart and soul and all of her efforts into that made that possible, and the way we were able to proceed with those cases, which may be difficult to do in the same way at the ICC. There's certainly other examples, and one involves Human Rights Watch itself and my friend Reed Brody, but there's been discussion about the Habre case. And the Habre case is such an inspiration because it tells me how important it is and how powerful it can be if you have strong documentary evidence in your possession. And the material that Reed and others found, even 10 years after the crimes in the DDS, in La Piscine, in N'Djamena, which included, allegedly, we were waiting for the judgment, but the records of the people sent for torture with the handwriting, the alleged handwriting of the president saying on there, "Don't let anybody out alive." I mean, with that kind of evidence, it's no wonder that, the Belgian prosecutors said, yes, I want this case. If they're not going to do it, I'll even go to the International Court of Justice and seek an order to extradite or prosecute, because this is the best thing we've ever seen. And in the hands of the victims, pushing this forward, even with the resistances we had from former President Wade and the mixed feelings in some places, but I think in the end a genuine effort by the African Union, we're able to get this case going. But that's because of the quality of the evidence and the advocacy of the victims. But if they'd just been reporting a narrative or what people said, there are a lot of nasty dictators from 25 years ago on which their narratives. There was solid evidence. Now, one of the things that's happening in this area, and I don't know how many minutes do I have left?
You have 7 minutes.
Oh, excellent. Okay. Because this gets into new things that are happening in this area, and admittedly with some controversy, and I'm engaging in it myself as a kind of informal advisor, but particularly because of the recognition that even the UN Commission on Inquiry on Syria wasn't going to be able to document the evidence, or bring in the documentary evidence, and there was at least 600,000 pages of documentary evidence that had fallen to the opposition that was available in Turkey. Secretary Clinton called in Istanbul in April of 2012 for the establishment of a Syrian Justice and Accountability Center with a board of Syrians and with international experts who would then work as a hub to civil society supported efforts to collect information in a professional way that would also build capacity for those actors for the future of a judicial process that we hope will follow in Syria and in the region. This led to the support of a number of initiatives, including the group CIJA, which is now called the Commission on International Justice and Accountability, that received about $1 million in funding from SJAC. CIJA has now collected 800,000 pages of documents. It has a names list in Arabic, optical character recognition, of 600,000 names involved in potential crimes in Syria. It has 470,000 videos analyzing the metadata on those and others that are capturing, because sometimes this stuff goes up on the internet or social media and goes down in 2 hours, and you've got to take it down on a constant basis. It now has 135 employees, almost twice what the ICC does, okay, that are working in investigations, half of them Syrian, some, and many of them in Syria, in areas under various controls, collecting information. Many of veterans of the international tribunals, like two people who were chiefs, chef de cabinet, presidents of tribunals, are now working for them, drafting, just now finishing 4 major pretrial briefs on cases involving dozens of potential suspects in each of the sectors of the Syrian state and also in ISIS. And now looking to move some of that into the Iraqi context. Challenge, of course, here is people say, well, this is privatization. This is like, contract law enforcement, et cetera. Obviously, we would be much better off if we had a mechanism under the United Nations to collect information in these kind of places, if we were doing the work in Geneva, which may not be the work of Geneva, to collect things according to an investigative standard. But it is being gathered in a way that can be transferred, and now is being transferred, to law enforcement authorities in third states, and is in the process of being used in prosecutions in European courts by war crimes units that had previously done cases out of Rwanda and Guatemala and elsewhere. But hopefully will lay the foundation at the end of the day for a mixed court or a hybrid court or ad hoc court or an ICC referral of major players, but with another court doing other cases. Our friend Yasmin Suka, who did such a great job on this previous panel and in so many areas, one of the things she didn't mention is that she's the founding director of a similar effort, handling things in a somewhat different way, and a different kind of evidence, but also supported with contributions from public agencies. The International Truth and Justice Program, or project, for Sri Lanka, some of which work became public during the Sexual and Gender-Based Violence Summit in London in June of 2014, where she had collected 40 statements, 20 from men, 20 from women, who had been subject to sexual violence, much of it post-conflict, people that had gone back to Sri Lanka believing it was safe and were then dragged into custody, tortured, and sexually abused serially over the course of weeks and months, and eventually through bribery or some other way managed to get out of the country and provide this information. But those statements were carefully taken, corroborated with other evidence. Members of the English bar cross-examined, as tough as that can be, these witnesses on their statements, on the inconsistencies. And that work is continuing, and sadly, even with the transition in Sri Lanka, as she will tell you, and obviously we're glad to be rid of the government. I'm in a private capacity, I can say that, and I could say that on behalf of the United States, to be frank, of the Rajapaksas, but we're still waiting for justice by the new government, and some of these very abuses continue as your project continues to show. But these kinds of efforts, I think, will be increasingly essential if we're going to lay the foundation for prosecution when it becomes possible. But having, as I say, as in the case of Habri, that strong evidence can really hasten that day. Of course, it's essential, one, that these operations follow the highest standards, that they have legal advisors and people that have worked and standards in each case, because obviously once that evidence is presented, as we know, and we can remember the criticism of intermediaries in the Lubanga case, and the assurance that this is being done properly will be essential to making it useful. And if in the end there's a failure in that respect, then the evidence won't come in, and the case, no matter how well supported, could fail. But this, and also the absolute necessity that it be not a Western or a Northern or any kind of operation, but that it be an operation that really is conducted with and for the victims and survivors of these cases, that at the same time can help capacitate them for the future when it comes to criminal justice in court, which is where obviously we want these cases to go. Thank you.
Thank you. All right, we'll now switch our focus somewhat to more of the domestic context, and we'll hear from Angela of the essential work that she's done with the Southern Africa Litigation Center, excuse me.
Thank you, Hannah. As introduced, my name is Angela Mudukuti, and I must just take the opportunity to thank our hosts and the conveners of this very interesting gathering. I think it's been a very fruitful gathering so far, so thank you. As Hannah has mentioned, civil society organizations play an indispensable role in the quest for justice and the protection of human rights. Our recent victory in the Supreme Court of Appeal pertaining to South Africa's failure to arrest President Bashir is just one example of how civil society can make a difference. And on that score, I must take the opportunity to thank the broader international community for being so supportive of this case. Domestically, since this case, we faced many challenges and often felt like the lone voice on the issue, but the support from the international community has been overwhelming and very encouraging, and that includes most of you in this room. Also, to acknowledge Max du Plessis and the other advocates on the case, it was a pleasure to work with these great minds on this issue. So, whilst I'm not discussing the Bashir case in detail, I will, with the indulgence of the chair, take questions on the issue if they come up during the process. Because I think it's quite an interesting journey we embarked on in 2015 when President Bashir came to South Africa. I know tomorrow Max, Chris, Dapo, and Dira will provide you with a fascinating legal analysis of the situation, so I will leave that in their very capable hands. Today, however, what I'm tasked with discussing is civil society and investigations for international crimes. Of course, there are all sorts of relevant questions like, should civil society organizations be doing investigations if they don't have the requisite skills? Are they doing more harm than good? Are they failing to collect evidence that is credible before courts? Are they re-traumatizing witnesses? These are all very important questions that I won't endeavor to answer, but will leave as food for thought for all of you. The reality on the ground is that the authorities that are mandated to investigate these crimes often cannot be trusted to do so, or simply lack the resources, the skills, or the capacity to investigate efficiently. And this is why many CSOs find themselves filling that gap. So in light of that, I'd like to discuss our experience with investigations. And of course, there are many people in this room who have a wealth of knowledge on the issue, and so I'm looking forward to your input as well. I'd like to begin by framing it by saying, as Hannah said, that I will focus on the domestic angle. And in the spirit of complementarity, I think best justice is often best served at the domestic level where possible. And that's what we aim to do at the Southern Africa Litigation Center. We aim to strengthen domestic systems and to make use of them. So from that, I will draw from two cases we've been involved in. The first one would be what's colloquially known as the Zimbabwe torture case. And here you see civil society, SALC, using litigation as a process to secure investigations. The case deals with crimes against humanity perpetrated in Zimbabwe by Zimbabweans against Zimbabweans. But in terms of South Africa's implementation of the Rome Statute Act and that element of universal jurisdiction, South Africa had a duty to investigate and possibly prosecute the perpetrators of these crimes. So what happened is, in 2008, or 2007 actually, SALC collected evidence from witnesses and victims. And by evidence, I mean affidavits indicating what had happened to them. It was mostly torture. And it was after a state-organized raid on the MDC, which was the then opposition party, headquarters in Harare. People were arrested and people were subsequently tortured. And so we collected affidavits from these victims, from witnesses, and corroborating evidence from doctors and lawyers. We compiled a dossier and presented it to the National Prosecuting Authority in South Africa, reminding them of their duty in terms of the ICC Act to investigate. Of course, as predicted, they declined to investigate. And that was then the opportunity to take their refusal on judicial review before the High Court. And once again, the objective was to secure an investigation into these crimes. And after winning in the High Court, the state took it on appeal to the Supreme Court of Appeal, where we were successful again, and finally to the Constitutional Court, where the Constitutional Court ruled that the South African authorities had a duty to investigate the crimes against humanity detailed in the dossier. And I'm happy to report that investigations are currently underway, and it's still a process we're assisting with. But once again, we can see that we had to use litigation to support an investigation. And again, we can see that SALC is not mandated to investigate. None of us are investigators by profession. But with the little evidence that we had, we managed to create a greater precedent for further investigations. So there are various ways in which you can go about it. The second case I'd like to highlight briefly is a case that Yasmin Suka has also spoken about briefly. And it's the case of Nokutula Simelane. She was an ANC activist acting against the apartheid government. She was a courier for the armed wing of the African National Congress, and she was betrayed by one of her own and arrested by the apartheid police in 1983. She was tortured and subsequently disappeared. No one has seen or heard of her since 1983. And so, of course, the assumption is that she was murdered. We know from the Truth and Reconciliation process who abducted her, who tortured her, and supposedly who murdered her. But no one applied for amnesty for her murder. They only applied for amnesty for her kidnapping and for her torture, but they were not granted amnesty for her torture. So, in terms of the TRC laws, those who failed to fully disclose were liable for prosecution. Yet, 33 years on, none of those prosecutions have taken place. And so Nokutula Simelane's sister, Tembin Kadimeng, in conjunction with many organizations, including the Foundation for Human Rights, came to us for assistance. And after years of meetings and correspondence with the various national directors of public prosecutions, we got nothing. And finally, in May 2015, we filed our papers to compel the National Prosecuting Authority to either A, make a decision to prosecute or not to prosecute, or B, institute a judicial inquest. Surprisingly, this encouraged the National Prosecuting Authority to bring the family back to the negotiation table. And finally, now it was February 2016 that they announced that they would prosecute the suspected perpetrators for her murder and her kidnapping. So again, you can see the long process involved in bringing these issues to the fore, but most importantly, again, SALC does not conduct investigations. So what we had to do in conjunction with the other organizations that were involved is hire a private investigator, a man by the name of Frank Dutton, who has a wealth of experience in TRC cases. And it was the identification of the fact that we needed to supplement the docket. We needed to gather more information, and we needed an expert to do that. And Frank Dutton was the man for the job. So the few points that I just want to leave you with, and also just to say that SALC is currently looking at business and human rights issues. And again, we realize our shortcomings, and so we've engaged the services of a corporate investigator, because that's the way you collect credible evidence that will hold water in court. So just to summarize, I need to say that I think civil society organizations in particular need to be cognizant of their weaknesses and their strengths. They need to engage private professional investigators, or to engage those who can provide psychosocial support for victims and witnesses when taking statements. They also need to think of creative ways to preserve and maintain evidence. We saw that last week a human rights organization based in Johannesburg was robbed. Their computers and their documents were taken. And if that is evidence you were planning to use before court, if you didn't have a backup or have it stored somewhere else, then it's gone. So these are other ways that civil society need to be creative as far as the preservation of evidence and information. And I think most importantly, civil society need to be engaged in capacity building for the authorities who are legally mandated to conduct investigations. Train your prosecutors, train your judges, train your lawyers, train your police. Because then, when they fail to do their job, it's not for lack of resources or lack of skill or capacity. So in summary, I would say that civil society organizations are instrumental in the process of securing accountability for international crimes. And as former Ambassador Rapp has already said, credible evidence and strong evidence is instrumental. Otherwise, the case will fall apart. Thank you.
right, thank you very much to both panelists for very interesting contributions. I myself have several questions, but I'll first open it up to the floor and collect 3 questions in the first round, and perhaps we'll get to my questions later on. All right.
Thank you very much to both panelists and to you also, Hannah. A simple question, and I'd like to address that to Ambassador Rapp. Is on the question of credible, strong, sound evidence. And I give you the example that you know very well as well, which is in relation to Syria. Last year, all the hoo-ha about gas being used, right, in Syria. And of course, there was a lot of discussion about both parties to the conflict utilizing that. So in the hope that there will be a process for taking that issue through a legal process, how can you build that kind of evidence in order to be able to take it to the next step? In that, I think it would be very good to hear from you and maybe also from Angela, because should one not be able to have strong, credible, reliable evidence, what do we do? Thank you.
Thank you. Okay, I think there was a question from Jim Goldstar.
Thank you very much, Hannah, and thanks so much to the panelists for great presentations. I wanted to just flag a note of amplification or encouragement and a note of caution. On the amplification or encouragement, I just wanted to underscore what was suggested about the power and critical role of civil society in so many of these efforts. I just wanted to highlight a couple of other examples outside this region. In Guatemala, a UN-backed mechanism that has been enforced for nearly a decade now achieved extraordinary breakthrough in respect of impunity, which had existed for years in that country, leading to path-breaking investigations and indictments, including of the highest levels in their government, on massive corruption charges. And all of that was possible because human rights organizations who were seeking accountability for crimes during a 36-year war in Guatemala were passionate and skilled in making the advocacy to bring such a special mechanism about. In Russia, where civil society space is closing fast, the Chechen Justice Initiative has documented dozens and dozens of cases and brought them before the European Court of Human Rights over the years, presenting a full documentary record and securing accountability for massive human rights abuses there. In Cambodia, the Extraordinary Chambers, which we talked about, which is UN-backed, relied for a great deal of its evidence on an independent documentary center created by civil society. And much of that documentation was extraordinarily valuable. So from an advocacy point of view, from a documentation point of view, from a litigation point of view, civil society has a fundamental role to play, really often the critical role in many of these efforts. Yet, I did want to throw a note of caution in, if I could, one of which is the space for civil society is closing in a number of countries, in part because of the effectiveness of their work. And in a number of countries represented in this room and beyond, civil society groups who have engaged in some of these efforts to document serious crimes and seek redress have experienced massive pushback and repression on the part of their governments. One question I have is whether the panel, the mechanism that you have all established, could play any role in speaking up on behalf of civil society actors who are risking their lives and their security in the pursuit of redress for war crimes in their own countries. The other note of caution is, frankly, given the horrific events that we have seen in different parts of the world, both in respect of terrorism and in respect of the migration flows that are happening, we are seeing from a funding perspective that funding resources are, there's enormous competition for these resources. And a number of governments who have been traditional supporters in this area of civil society work are frankly stretched very, very thin, and it's a very difficult environment in which to operate. So I think a challenge for all of us will be how we can expand the resource pool to allow these civil society activities, which are so critical, to continue. Thank you.
Thank you. We have one further question from Judge Goldstone, and then we'll start the next round with Bill Pace.
I just want to say that I think the role of civil society cannot be exaggerated. Without civil society pushing, there wouldn't be an ICC. Without civil society, there wouldn't have been Yugoslavia or Rwanda tribunals. The push came from civil society in all regions of the world, and that I think should be recognised. One point I'd like to raise for the consideration of the panel, as a former prosecutor, we were concerned frequently in the case of the former Yugoslavia and Rwanda with some civil society, some NGOs contaminating evidence through ignorance, with the best intention of getting affidavits from witnesses, which is the last thing that prosecutors would welcome. And I think there's a huge area for training of NGOs, particularly in new areas of war and the Commission of War Crimes.
Thank you. Ambassador Rapp, and then Angela's responses.
Yeah, quickly on these questions. First, in regard to the chemical weapons use. This is one area where there's been some multilateral success, as you may know, in the UN Security Council, and thanks to the OPCW. The El Ghouta attack in August, killing more than 1,200 people, horrendous, sarin gas. There frankly is no question that the regime is responsible for that crime, if one reads the fact-finding mission report of OPCW. But they're not in a position to actually connect the final the final dots, and that's led eventually to the establishment of this joint investigative mechanism that can take advantage of that information and go forward with it. At the same time, now we have by Daesh or ISIS alleged use of particularly mustard gas and ballistics, etc. Strongly suspected again. But that's something else that they will, I think, be able to deal with in this area. So hopefully, through the mechanisms that we have, and through, I think, the power and independence of the OPCW and the professionals that work for it, I think that's one place where eventually we can develop the evidence of this. Now, of course, there's other things in terms of responsibility of individual actors, and I know there have been defectors and others that have provided information about the bombing runs and what they were doing, et cetera. And some of that information and those names have been collected by these groups, and that can provide another piece to the kind of cases against the sorts of individuals that you could bring in. And Jim's point, obviously, agree entirely. I mean, the CSIG experience, which it's a fascinating one because it was an international thing established by the UN to help end impunity in that country, but not necessarily the impunity for the horrible human rights violations, for frankly the genocide against the Ixil and Maya people that happened there. But some of the same people that were involved in those crimes remained powerful figures in the state and behind the state who continued to corrupt the system. And the establishment of CSIG that really only deals with cases post-96, and the partnership of civil society with strong public prosecutors like our friend Claudia Paz, who served a term and then was replaced by the president, but even her successor, working in cooperation with these international prosecutors and investigators coming from the region, has been an immense success and led, of course, to the cases against the president and vice president and to their resignation. It also led to a number of reforms, including the establishment of high-risk courts and protection for their judges and investigators that in the past had been under horrible risk. I would replicate that model anywhere in the world, but obviously those who have power and are in a state or deep state will see it coming next time, and it may be difficult to use that model, but it's a fantastic one, though it was really called into being more on the corruption and organized crime issues than it was on the human rights issues. Finally, we had this question from Prosecutor Justice Goldstone in regard to the dangers of contamination by things done in an amateur fashion. And certainly those of us that are prosecutors always hate the fact that, you know, a statement comes into our possession from a witness that's very incomplete, taken early on, a later one has come in, and there's some minor inconsistencies between them, and certainly the second one is more comprehensive than the first. And so it's possible through cross-examination to make an argument that you've made up the rest of the details on the more comprehensive statement. And so one always has to be careful of this process. I will note there is an initiative led by the Public International Law and Policy Group together with the International Bar Association on part of this issue, which is particularly dealing with early responders and first responders and sometimes humanitarian actors that are reluctant to compromise their neutrality, but of course human rights first and all of that. They need to document what they can. They're working, they developed a draft protocol that's in discussion, this group of international civil society groups, to develop standards on, you know, with the first, second, and third rule be do no harm, but on gathering the kind of information that clearly isn't complete, but that can lead professional investigators to find the good evidence, et cetera. So I do think that these kind of efforts to professionalize it all through the stream are important. I'm also concerned, related to Jim's question and the whole question of the threat to civil society, and I see this even in Europe where there are groups associated with the Syrian government that are active in the diaspora, and sometimes family members of people that we're working with suddenly are pulled in for interrogation, torture, and maybe even death. Happened to somebody, a witness in a Northern European country just in the last few weeks, and it's the frightening thing in these areas that if you had an international court, if you had a domestic court with robust witness protection and other things to be able to deal with this, you have to really try to develop the ways to reduce risk and to do things so carefully and to maintain the security and not to let that kind of information, for heaven's sakes, be robbed. I mean, you lose the information, but the danger of it being out on the street and the kind of responsibility that any of us would feel if we took a statement and it somehow, in an unredacted form, identified a particular individual and it came into the hands of their enemies. So these are sort of the priority one in this area, which has the protection of individuals and the doing of no harm that has to underlie all of these efforts, even sometimes at the cost of obtaining the best possible evidence.
Thank you. Angela?
Just to add that I couldn't agree with you more, Justice Goldstone. This is the risk with civil society organizations doing a job they don't properly know how to do. And we've seen it as well, where you not only contaminate the evidence, but the witness, because you've taken a first statement, but it wasn't properly done. And you then have to go back to the witness, who's almost going through a second process of re-traumatization discussing this, and still will have to stand before a prosecutor and tell the same story again. And by the end of it, you just get witnesses who no longer want to be a part of the process because they've been through so much. So I think it really is an area for civil society to be sensitive and to get the requisite training or get the requisite professionals to do the job.
All right, thank you. I think we had a question from Bill Pace, and then we'll take 2 more questions in this round as well. Bill is the gentleman in the pink shirt there.
Well, quickly, just to again compliment the organizers. This has been another excellent panel, and Angela and Stephen have been brilliant, I think. And I'm reminded of how much crap is on the television, on the U.S. Congress and stuff in the United States, and you wish that sometimes some programs like this would show up and shock people. Another comment related to U.S. is that not a week goes by in the United States, media, newspapers, where terrible miscarriages of prosecutorial problems occur in our national legal system. So I do not want people to think, oh, well, the international system is really primitive and immature compared to national, because I don't think that is accurate. There are problems and we have to deal with them. Third, again, I think from the comments about all of the different tribunals and processes, and Jim Goldstone and others were mentioning. Just to remind, I know it's not popular in this meeting, but some of these things have taken decades. And the whole point of the permanent court by the governments and the NGOs in the 90s was, let's get a court that works, let's make it permanent so it's not ad hoc, and that we know some of these things are going to take time. But I do think there is some real justice for victims even when it happens after a long period of time. For the mandates of some of the NGOs that Stephen and others were mentioning, it took them also a long time for them to modify their own mandates so they could do some of this work on, say, the human rights organizations themselves. They had to go through lots of hard debates and discussions. And again, I think it has been shown that it's working out very much to the advantages. On the protection of human rights defenders and international justice defenders, again, a little self-serving, but I really think you cannot overestimate the importance of the linkage between the international NGOs, the regional NGOs, and the national NGOs in a synergy of trying to protect each other's work. That we have access to governments that should be standing up to protect NGO defenders. We have access to the European Union, to other mechanisms that we can help activate, and we really need to continue to worry about this closing of the space that was mentioned. And the last thing is on the memory issue, is that part of this whole enterprise is to stop this nonsense that we've lived through for hundreds, if not thousands of years, of the denial of what really happened. And hopefully this era now, in the last 25 years, and including the Nuremberg process, we will see that we have put in a brick on this that won't dissolve in time. Thank you.
Thank you. Yes, Elizabeth.
Thank you very much, and thank you for both of your presentations, which were excellent. I see a difference between the investigations, Angela, that you were talking about to support strategic litigation, and then the investigations, Ambassador Rapp, that will eventually stand in for the investigations that otherwise would be done by national authorities or international authorities. And I guess my question goes to those kinds of investigations. You explained quite well why this space has opened up, where there is no one who yet has a justice mandate. And so there is a gap. Evidence is there. Evidence could disappear if we wait for a justice mandate. But I wonder if there shouldn't be a relatively bright line between human rights documentation and advocacy based on human rights documentation, which could be advocacy to stop abuses, it could be advocacy to catalyze justice processes on the one hand, and then organizations which really just have that limited mandate, a huge mandate, but a limited mandate to conduct and to prepare kind of case-ready files. Do you see a benefit to having that separation? Do you see a tension between doing human rights advocacy and doing that kind of an investigation that might stand in one day for what otherwise would be done by a national or an internationally mandated jurisdiction? And I think that part of the question comes up because you can see that there might be real tensions in the methodologies. So you might want to publicize, as a human rights organization, you might really want to publicize the testimony you're getting from witnesses because that's what's going to create the climate that's necessary for accountability. Whereas you might really not want to do that if your goal is to prepare a case file. So just wondering how you see the relationship between those two different mandates and whether is it a matter of training human rights documenters to do it in a way that's more helpful for criminal accountability? Or is it better to just say, look, these are really different things, and these have different mandates and therefore different methodologies?
Thank you. We have a question from Femi Falana and then Natalia Molokome, and then we'll come back for responses.
For Angela, in the course of your investigations here, have you had cause to use the Freedom of Information law to obtain information from the government or security agencies? Secondly, and this is just a small comment, I think in the course of discussing the role of civil society organizations, we should always be conscious to draw a line of dichotomy between genuine civil society organizations and organizations set up by the government to frustrate the work of civil society organizations.
She's prepared.
Yeah, thanks very much. Maybe, Femi, I'm happy you came before me, because then maybe I can toss that one around and wear my government hat and say, we in government also are wary of NGOs that appear to be promoting the agendas, the political agendas of other governments. I think that is a reality. But taking my government hat off now, I do accept and I commend the role of NGOs and civil society generally, especially in the area. I'm not so familiar with your work, Angela, with respect to the investigation, and I'm happy Judge Goldstein there sort of cautioned NGOs against, doing things they are not trained to do, and that you yourself had said, modestly as always, you realize that there are risks there as well. But I just wanted to say that NGOs can play a very important role in public interest litigation, even outside the war crimes area. And I have said before in Angela's presence that I say this tongue-in-cheek because the Southern African Litigation Center has been a thorn on my side. In the Botswana government, they've supported a couple of cases, one of which they've been successful. The other one, which I hope they're going to lose, but which has to do with the provision of antiretroviral therapy to foreigners in Botswana, which we as a government are saying, look, we cannot really, in view of all the immigration and all that, afford to give ARV therapy to everybody. I think we are still on appeal. But just to say that I think that there is a huge role for NGOs to play. And in countries like Botswana, where the space for NGOs, it's not perfect. I think what you said about also working with government agencies like the judiciary and so on, I think it would be a very good PR exercise, because some of your public interest litigation is useful to us as government. But if we begin to treat you like the enemy, or you come in and do your case and leave, as if, you then, it becomes a bit adversarial, because you are mostly involved in litigation. So I was also happy to hear that this is something that you'd be thinking of doing. Another thing, and I think that's where I started and I'll end there, is with, I think depending on where you operate, civil society organizations can also run the risk of being suspected, as I said, to be agents of certain political, I think that's a risk. I've been in the NGO movement before. And and you need to look also at the space you're operating. There are certain things which particular governments will be very sensitive about. Certain NGOs they would not want, for example, their local NGOs to be involved in, which they consider almost subversive. So you have to be very selective as well and very strategic, and to make sure that your assistance is not going to be, to be the opposite, achieve the opposite effect. But certainly the role of NGOs, I commend it, and I think in my own country, certainly NGOs like yourselves, like the Bonella in Botswana, the HIV AIDS Association, they have assisted our courts come up with decisions which our parliamentarians or our policymakers don't dare to make, change the law to adapt to changing conditions, so that you bring that opportunity for courts to then rule on the situation on a constitutional basis. So congratulations.
Okay, Angela, can we hear your responses?
Thank you very much. Atalia and I have a love-hate relationship. She neglects to mention that we won the antiretroviral case at the High Court, by the way. That's true, there is an appeal indeed. To address your question about access to information, it is something we are looking to do. In South Africa, I think there's very strong legislation in the form of the Promotion of Access to Information Act. And you can use it against the government, you can also use it against private entities. And we see in our business and human rights work that it's become an instrumental tool in securing information from corporate entities, for example. But it is an area we'd like to develop further.
All right, Stephen.
Follow several of these questions, but first just to point on Bill and both of us being Americans, he raised a very valid concern, but when these cases happen of police abuse, these are violations of people's civil rights, and some of the people like our friend Alan Teeger, who tomorrow we hope will take a verdict of conviction, I'll save my own instinct in it, in the case of Heritage, was earlier a civil rights prosecutor who prosecuted the Rodney King case in federal court after it was lost in state court, police officers beating an innocent man on the streets of Los Angeles in the view of video cameras. And so these kinds of efforts are important in all our societies, and I'm proud of what Loretta Lynch, who's someone we brought to the Rwanda Tribunal to work with us for a while on contempt cases, is doing, pressing ahead with Ferguson, Missouri, and insisting that they live up to the terms of a settlement and forcing that through this week. So, but every country has these challenges and has to meet them every day, to respect the rule of law and to make sure those that are sworn to uphold the law are following its highest standards. On the question of distinction, I agree completely that there's this advocacy role where one wants to be out there pressing the cause, relating what's occurring. Sometimes that can be quite inconsistent from the careful role of developing cases. And certainly the kind of operation that we've seen developing in the Syrian context among one or two of the major organizations, it has been to operate much more like an office of the prosecutor in exile to some extent. Now, frankly, we'd like to have an investigative commission like the UNIIC in Lebanon or the SITF in Kosovo, something that would have an official mandate doing that. But I think that's careful kind of work, and while they can talk about what they're doing, they can't talk about it very specifically. So that there is this distinction that I think is important to respect. That said, human rights actors, humanitarian actors will sometimes come across documentary evidence, sometimes have an opportunity to sketch or photograph a mass grave or something else, that there can be valuable information gained that may be of value to investigations when they have that kind of access. And the question of it at some point, whether that could be made available to law enforcement and on what basis, is something I think that's quite important. And frankly, many human rights organizations very much want to work with prosecutors and others and to bring this information forth. Talia, I think I heard you begin to raise some issue about human rights organizations and who do they represent, and I've noted in the United States we used to talk about grassroots organizations, and then corporate interests started forming their own so-called grassroots organizations that sounded just like the group that was representing the public interest. We called those AstroTurf organizations. But frankly, in this field, we can have the same thing. And I know in the context of what's happening in eastern Ukraine, there are groups that are coming forth with information that I don't trust. They may be right, but they're exaggerating enormously offenses that may be committed by those that are fighting on the Ukrainian side. Maybe they're not, et cetera. And so you do get this kind of competition and disinformation that's occurring out there. And of course, the best antidote for that is to make sure that people follow high standards and that there's an ability to verify this information. Because I think to the extent that advocacy works for one cause, it will also work for the other, and can be also used as a way to intimidate and keep people from speaking out. I will note, I come from the common law system, and I know when I first confronted judges, and a majority of our judges in the tribunals come from civil law countries, and when I worked with European prosecutors on cases that they were pursuing on Rwanda, initially it was hard to get my head around the civil law process. But we were talking in the previous session about the representation of victims, and particularly the Havre case, but also some of the things that have happened in Mali and in Cote d'Ivoire and elsewhere. And which I hope will happen in the Central African Republic, I think really do give me hope that victims represented in court and in national courts empowered with assistance in developing strong evidence, become, in my view, the most powerful prosecutors. And I don't want to make light of Mbaki Fall and his work as the prosecutor in the Habre case, doing a professional job, but if you've been to the trial in that case and you watch the victims and the work that they're doing, they are frankly carrying the lion's share of that case. And so we do have in civil law systems and in the ICC now, I think, a new vector that officially moves what can be gathered by civil society into the judicial process in a regulated way that I think is one of the most exciting developments that I've seen in the last couple of years.
Thank you. All right, I don't see any immediate hands shooting up, so I'll exercise my chair's prerogative at this point to ask...
And adjourn.
Almost. Just to ask one question to each of our panelists. First to Stephen, I was wondering, one of the ways that civil society can be involved beyond investigation is through the submission of amicus briefs. And amicus briefs we saw had a significant impact at both the Special Court for Sierra Leone and the Rwanda Tribunal. And I was wondering if you had any reflections on the role played by those briefs at the tribunal, whether you think they had a significant impact on the jurisprudence, and whether this is an institution that is playing its proper role in international criminal proceedings more generally. And to Angela, I was wondering whether you think there are distinctive challenges and opportunities that face African non-governmental organizations in the investigation of international crimes, and if so, if you could share your reflections on that issue.
Well, I'd love to see the amicus briefs come in on these important and significant issues. Understand that from the point of view of the prosecutor, they wouldn't necessarily come in on the side of the prosecutor's interest, but I do think that there are that it's been extremely valuable in each of the tribunals, and this is often a process where the judges have to decide whether to receive it, and in some places it's been harder than others, but this can be valuable to bring more information to the judge's attention. To be frank, as someone that's worked in tribunals, I know when I was at the Special Court for Sierra Leone, when I arrived, we were already closing. I had a whole different trial team in the AFRC case on prosecution than I had on defense. It was hard to keep my international staff there. It was often challenging to get people who were up to date on every aspect of the law and legal development, and that was critically important to have that kind of information in front of the judges. And so I certainly encourage that. Sometimes the same arguments come in from a variety of groups and are perhaps repetitive, but if it's well researched and based, and it deals with what's happening all over the world in terms of particularly things like customary law, and I think it's of immense value to those of us that are involved in the process.
Okay, thank you. And Angela, on 30 seconds reflection on the distinctive role of African civil society groups.
I think there are a number of challenges, and they came up yesterday, they came up today, but the first thing that has already been mentioned is the shrinking space for human rights organizations. Human rights organizations work under immense stress and in difficult situations, and they put their lives on the line as well as the lives of the victims and the witnesses they're trying to help. And also, I think there's a lack of information. Information doesn't get to the people who need to stand up for their rights. They don't know what their rights are. They don't know what they're entitled to. And also, as was mentioned this morning, poverty is a real problem. So if I'm hungry and you're asking me to come and be a witness in a case, I mean, priorities are different. So I think the continent does face several challenges that make it more difficult to obtain the information you need to protect human rights.
Thank you. All right, is there any final question from the floor?
Bill.
I can't read my own writing.
You had another.
And I wanted to make a connection. The connection was on the selectivity issue, is that sometimes it may take a number of years before you're going to get the non-selectivity realized. And so we have enormous crimes that have occurred in the last 10 or 15 years. Many, since they're after 2002, are going to be subject to adjudication, investigation, and prosecution at some point. And so when we talk about Guatemala and Cambodia and other things. That may happen. So don't, just because you're saying, oh, well, you're just doing ours but not these others, they may happen at some point. That was the genius, I think, of the Rome Statute being a permanent statute.
And that's a very important message whenever we're dealing, and understand the people that are working in Syria and Iraq helping on this every other day come in and say, what difference does it make, because this is going to happen, and then you tell them about other situations where things were happening. No one ever thought in the former Yugoslavia that Milosevic would ever be in the dock, or in West Africa that Charles Taylor would be. And those days will arrive. And even from the point of view of sort of global fairness in this regard, as each of these cases are brought, they establish standards. Others can work on cases against even leaders of powerful countries. And that will increase the pressure for those cases to come forth in home countries eventually after transition, sometimes not immediately, or in the courts of third countries. And so the more of this that goes on, and the more that people are developing, collecting the evidence when it's available, then the better the chance. On the other hand, you could have a situation like Bangladesh, where they finally went to deal with the horrible crimes of '71 with millions of victims, but frankly they hadn't collected the evidence, and the cases have been criticized as politically motivated. The public strongly supports that process, but having evaluated the evidence, the connections, frankly, are lacking in most of those cases, and I wish for the sake of the public and the survivors and the victims that they had the kind of record that it's been possible to build more recently.
All right, I think that's a fantastic place to call an end to this panel. Thank you very much to both of our panelists. Can we please